Welcome to Travel Arbitration Frequently Asked Questions, here to help users of the Travel Arbitration Scheme 2024 edition. These FAQs have been compiled to help you to understand the scheme better, and this video will be constantly reviewed and updated. For more details, please visit the FAQs section of the Travel Arbitration webpage on the Hunt ADR website. On this page, you will find other articles and resources which may be of interest and assistance. Most importantly, you are encouraged to read the rules of the scheme and any guidance notes accompanying the rules before you make an application. Now, let's look at some of your most frequently asked questions in more detail. What is arbitration? Arbitration is a cost-effective, speedier, and less formal alternative to resolving your dispute through the courts. It is conducted privately based on written documentation and evidence submitted to us by you and by the travel company. What is travel arbitration? Travel arbitration is our independent arbitration service used to resolve disputes between consumers and travel companies who use the scheme, including members of APTA as well as others, including Love Holidays and On the Beach. Under the scheme, an arbitrator is appointed to make a decision known as an award, based on the evidence provided to them by the parties in dispute. The award is binding on the parties, and it takes less time and costs less money to take a dispute through arbitration than it does to go through the court system. For more information about the difference in costs between court and arbitration, please see our article, which goes into some detail and can be found on the Hunt ADR website under the Travel Arbitration tab. The scheme deals with alleged breaches of contract or negligence between customers and travel companies and cannot deal with any criminal cases or those of assault, either physical or sexual. The scheme is provided so that customers can have disputes resolved without having to go to court and without having to go to the expense of instructing solicitors, though you may choose to use a solicitor if you like at your own expense. If your dispute is with an APTA member, you can read the rules of the scheme on the APTA website ADR Schemes page. The rules are very important, so if you are thinking of using the scheme, you need to read them carefully. If you are in dispute with a company who is not a member of APTA, you need to contact them direct and ask them for a link to the rules. Who runs Travel Arbitration? Travel Arbitration is a trading brand of Hunt ADR who run the scheme. As well as providing travel arbitration, we provide mediation and arbitration services to a number of organizations and private parties, as well as providing training and CPD events to mediators, arbitrators, and other professionals. Who are APTA and what is their involvement? APTA is the UK's largest travel association, representing travel agents and tour operators that sell £37 billion of holidays and other travel arrangements each year. APTA has been a trusted travel brand for more than 65 years, offering advice and guidance to the travelling public, as well as leading the travel industry in supporting high service standards, working with its members on health and safety, and promoting responsible tourism at home and abroad. APTA has had an arbitration scheme available to resolve consumer disputes with its members for more than 40 years, and now contracts with Hunt ADR to provide the service. Not all users of the scheme are members of APTA. For example, Love Holidays and On the Beach have their own version of the rules and operate outside of APTA membership. If you are in dispute with any holiday company, you must complain to them first and give them the opportunity to settle with you. We will not issue application forms for arbitration, and we cannot get involved if you have a dispute until you have submitted a properly completed application form, which is issued either by APTA or, in cases where the company is not a member of APTA, by the holiday company itself. Who are ODR Plat and what is their involvement? Travel Arbitration is a Hunt ADR service supported by technology and case management provided by ODR Plat, a provider of integrated online dispute resolution platforms. Is travel arbitration independent? Yes, Hunt ADR has no personal interest in the outcome of a case. Our role is to make sure we appoint arbitrators who publish clear, binding final awards, which end the dispute more quickly and cost-effectively than a court would. Can you advise us on whether we have a good case? All the advice we can give is here and in the associated blogs and podcasts. We are unable to offer any guidance on chances of success. For the arbitration scheme to work properly, we must remain, at all times, independent and impartial, and this means we can only offer procedural guidance and cannot offer advice to either party on the merits of their respective cases. How much will travel arbitration cost me? To register a claim with us, you need to pay £150. This covers you for a claim of up to £25,000. These fees are payable to Hunt ADR when making an application and are non-refundable. If your case settles with the travel company before an arbitrator is appointed, then you should make sure that you ask for reimbursement of your registration fee in the settlement with the travel company. Remember, arbitration is less expensive than going to court, and you can read more about this in our article on the cost of arbitration v. court, available on the Hunt ADR website under the Travel Arbitration tab. How do I make an application to use travel arbitration? If your travel company is a member of APTA, before you can apply to use the scheme, you must have complained to the APTA member and given them the opportunity to resolve your complaint. If they are not able or not prepared to settle with you, then you can take your complaint to APTA, who will try and help you and the other party find a solution. Once that route is exhausted, APTA will write to you to let you know about what you could do next. They will tell you you have the option to go to court or to arbitration. You can only apply to use the scheme once you have that communication from APTA, which includes a reference number which allows you to access the application portal. Please remember that your application must be made within 18 months from your return date or intended return date from holiday. If you're in dispute with a travel company which is not a member of APTA, then you must go direct to them. We cannot get involved until an application is made and accepted by us. I don't want to use the portal. Can I apply via post? Yes, of course. As long as you have the application form and your unique reference number, you can apply by post. Details are given at the appropriate time. Please remember that your application must be made within 18 months from your return date from holiday. What is an arbitrator? An arbitrator is a neutral person who makes a legal and binding decision after considering the evidence that both the consumer and the travel company submit. The role of an arbitrator is similar to that of a judge. Arbitration is a legal process, and the arbitrator must make their decision based on the law. Our arbitrators are all independent professionals, most of who are members of the Chartered Institute of Arbitrators. Each arbitrator has either been invited to join the panel based on their expertise, or has otherwise satisfied us of their ability to arbitrate on disputes of this nature. It is important to note that arbitrators are not employed by Hunt ADR. They are contracted to provide arbitration on a case-by-case basis. The current list includes arbitrators who have published awards in thousands of travel-related cases. Arbitrators are appointed according to a cab rank system used widely in legal cases. This means that the arbitrator is selected on their availability and not specifically chosen for a particular case. What is an award? The award is the document with the decision that the arbitrator produces once he or she has considered all the evidence. All awards must stand up to scrutiny in the relevant court if they are appealed, which means they take matters of independence and impartiality very seriously. The parties are legally bound by the award, which is enforceable in the courts, subject to any provisions in the rules. The award contains legally binding orders for the parties and details of the case, and the arbitrator's explanation as to why they decided the case as they did. When parties receive the award, it is our goal that it will be clearly written and understandable and not contain legal jargon. Many awards are proofread by professional proofreaders before they are issued, ensuring that accidental slips and errors are kept to a minimum. We also spot check awards post-publication and will follow up with any comments, including specifying areas for praise and for improvement. Can I claim for flight delays? If your holiday was a package holiday and part of your complaint relates to a flight delay, then it can be dealt with by travel arbitration. If your claim is solely for flight delays, this scheme does not apply. They are dealt with by other providers approved by the Civil Aviation Authority specifically to deal with flight delays. What happens if I win or if I lose? If you win, the travel company will send you the money they owe you directly. Payment is due within 21 days from the date the award is issued, unless either party has approached Hunt ADR within 28 days of the award being issued, asking for an appeal. If you do not receive payment within 21 days, then you should, in the first instance, contact the travel company and APTA where the travel company is a member of APTA. If you lose or you're awarded less than or the same as an amount that was previously offered to you by the travel company, you'll be ordered to pay a further amount to the travel company, which will be equal to the £150 you paid as a registration fee, but no more than that. For example, if the travel company offers you £2,800 and you decline the offer, and then the arbitrator awards you £2,700, you will have to pay £150 back to the travel company. You are also responsible for the cost of making your case, for example, for photocopying and postage. How long will it be before I know the outcome? You should expect to hear the outcome within 8 to 12 weeks from the date that the application for arbitration was received by Hunt ADR. This is much quicker than going to court, which can take more than a year from start to finish. Can the arbitrator or Hunt ADR advise me on my case? No. The arbitrator and Hunt ADR are impartial and cannot act as a consultant or advisor to either party. Hunt ADR can only advise you on procedural matters. If necessary, advice should be sought from a solicitor or Citizens Advice Bureau. Do I need legal representation? No, but you can choose to have legal representation if you want to. Arbitrators do not expect you to have legal representation, though you may choose to have it at your own cost. This is your right. Please remember that your legal costs cannot be reclaimed, even if you win. If my claim is unsuccessful, what can I do next? There are only 2 routes for challenge against the award. You can appeal through the High Court within 28 days of receiving the award, or you can request an appeal under the Travel Arbitration Scheme appeals procedure. Any application for appeal must be made to Hunt ADR within 28 days of receiving the award. These deadlines are strictly enforced, and Hunt ADR has no power to extend them in any circumstances. If you do not apply in time, you will lose the right of appeal. There is no other way to challenge the award. You may not like an award, but remember that does not mean that the award is wrong in law. Appeals will normally require evidence of a serious error in law or misconduct on the part of the arbitrator. In order to have an appeal considered by the High Court, you may need to instruct a solicitor. We cover the costs of appeal in our costs article referred to earlier. Can I share my award or the outcome with the media, or go to them during the arbitration process? In simple terms, the rules of the scheme include a confidentiality clause at Rule 7. Arbitration is a legal process. The rules which you and the other party have entered into, in your case voluntarily, state that the matter must be treated as confidential, and if that confidentiality is breached, then any party could seek legal remedy. Therefore, you should exercise caution if you are considering making the contents of an award or your case public. Ultimately, you enter into this process subject to the rules, and if you prefer to run the complaint through the media, that is inconsistent with the arbitration process you and the other party have agreed to enter into. If the media report your case before the arbitration is completed, then any arbitrator appointed may see the coverage, and possibly, as a result, may not continue with the appointment as it could prejudice their view and the arbitration process. We will not engage with media inquiries about the running of this scheme. Policy on abusive users. We will not tolerate abusive actions towards our staff. We are not obliged to work with people who are abusive to us. We are not a holiday company, we are not ABTA, we are not a regulator or a public service provider. Our role is to provide independent arbitration services once we have received and accepted a valid application for arbitration. We reserve the right to refuse to accept an application, and we will not deal with anyone who is abusive or uses foul or threatening language either verbally or in writing. How do I complain about something you have done? Our complaints procedure sets out how to complain and what you can complain to us about. Please note when considering making a complaint that we can only deal with service complaints. We have no legal right to amend an award, and it may be that your only recourse if you want to have the award changed is to appeal. Can I have an extension for bank holidays, Christmas or Easter periods? In order to ensure that the scheme runs properly, we need to adhere strictly to deadlines for submissions. However, where a bank holiday arises during the process, the following extensions apply. Easter bank holiday extended by 7 days. May bank holiday extended by 3 days. August bank holiday extended by 3 days. Christmas and New Year extended by 10 days in total. The only exception to the above is where either party requests an extension of time and have it agreed and acknowledged by Hunt ADR. Thank you for watching this video. We hope it is of assistance to you. If you can think of anything else we might include in this video to help users, please let us know. Remember, if you want to apply to use the scheme, you need to complete any complaints processes with the travel company first, then go to ABTA, where the complaint relates to an ABTA member, and only then will you be given access to the application form. If you come to us too early, we will not be able to assist.